ladies and gentlemen, distinguished guests on and off the dais, I, Prachi Bhardwaj, on behalf of EBC, feel deeply honored to welcome you all on this momentous occasion where we gather to release Prevention of Money Laundering Act 2002, a practitioner's guide by Mr. Jai Anant Dehadrai. Published by EBC, this book is a comprehensive practitioner's guide offering a detailed chapter-wise explanation of the Prevention of Money Laundering Act, along with practical insights on compliance. As we gather here today to celebrate the release of this significant book, I'd like to take a moment to outline the flow of our event. We will kick things off with an engaging panel discussion on the topic Procedural Fairness in PMLA, followed by highly anticipated book release by esteemed Justice JK Maheshwari, Judge, Supreme Court of India, and Mr. Tushar Mehta, Solicitor General of India, who will be joining us shortly. Now let me introduce our distinguished guest and the panelists on the dais. Please join me in welcoming our first panelist, Mr. Atmanam Natkarni, the esteemed former Additional Solicitor General and a prominent figure in Indian law. With a career spanning decades, Mr. Natkarni served as Advocate General of Goa before being appointed as Additional Solicitor General in 2016. In 2019, he was reappointed as Additional Solicitor General in the Supreme Court of India, showcasing his expertise and commitment to justice. His dedication to the legal profession and his deep understanding of the law makes him a key player in shaping the legal landscape of India. I would like to request Ms. Bhumika Indolia to felicitate Mr. Natkarni. Our next panelist is a distinguished senior advocate at the Delhi High Court, renowned for his sharp legal acumen and engaging personality. He is also an accomplished author, best known for his hilarious non-story, How Gorongo Lost His O. Despite his notable success, he humorously refers to himself as a struggling lawyer. On Twitter, his sharp observations and playful commentary have garnered him a loyal following, proving that laughter can indeed coexist with law. Please join me in welcoming Mr. Sanjay Ghosh. I would like to request Ms. Nilufer Bhateja to please felicitate Mr. Ghosh. Our next guest, Mr. Vijay Agarwal, is a formidable criminal lawyer based in Delhi with over 2 decades of experience navigating the intricate corridors of the justice in India. Since 2000, he has made his mark in prominent courts in India, including the Supreme Court and the Delhi High Court. Mr. Agarwal has skillfully handled high-profile cases, including the 2G Spectrum case and the $2 billion Punjab National Bank fraud case. With a reputation for defending notable cases, Mr. Agarwal stands as a beacon of legal expertise and tenacity in the Indian legal landscape. I would like to request Ms. Tejaswini Mishra to felicitate Mr. Agarwal. Please join me in welcoming our next guest, Mr. Zohaib Hussain, an Oxford-educated legal mind with an unwavering passion for justice. His significant contributions to landmark cases, including the high-profile Vodafone dispute, highlights his exceptional skill and dedication. Currently, he serves as a distinguished Group A panel counsel representing the central government in crucial matters before the Supreme Court of India. With an impressive track record and a steadfast commitment, he is truly a formidable presence in the legal arena. I would like to request Ms. Diksha Dabas to felicitate Mr. Hussain. I am now excited to introduce our dynamic moderator, Ms. Agam Kaur. After graduating from law school in 2013, Ms. Kaur quickly made her mark in the court corridors by working on the high-profile 2G spectrum case. She then took on the pivotal role as a legal consultant with the Enforcement Directorate, where she passionately argued numerous cases before the Appellate Tribunal for PMLA and FEMA over 3 impactful years. With her diverse experience and sharp legal insight, Ms. Kaur is poised to lead today's discussion and expertise with flair. I would like to request Ms. Sonali Ahuja to felicitate Ms. Kaur. Please join me in welcoming the man of the moment, Mr. Jai Anant Dehadrai. Primarily a white-collar criminal law practitioner, Mr. Dehadrai has navigated a diverse legal landscape, tackling a wide array of criminal, commercial, disability, and environmental matters, to name a few. Beyond his impressive legal expertise, Mr. Dehadrai is also a passionate author, culminating in the release of his latest work that we have all gathered to witness the release of. And also, please, let's give a big round of applause for him, because he is the newest advocate on record in the town. I would like to request Ms. Diksha Dabas to please felicitate Mr. Dehadrai. Founded in 1942 by 2 brothers, EBC has grown from his humble beginnings in law book selling and publishing to India's largest legal publishing house that serves as a vital research resource for legal professionals and students. As the director of EBC and associate editor at Supreme Court cases, Mr. Sudeep Malik, with his visionary leadership, has propelled the organization to new heights. His strategic insights and innovative approaches have significantly contributed to the growth and prominence of EBC. I would like to request Ms. Sonali Ahuja to please felicitate Mr. Sudeep Malik. I would now like to request Mr. Sudeep Malik to please welcome the audience with his insightful address.
Thank you, Prachi. I believe my Lord Justice Maheshwari and Mr. Tushar Mehta, learned Solicitor General, are on their way. I welcome them in their absence. And I welcome all our panelists, Mr. Nadkarni and Mr. Ghosh, senior advocates. Thank you for being here. Mr. Vijay Agarwal, Mr. Zohaib Hussain, Ms. Agam Kaur, advocates. We are very happy to have you on this panel. And of course, our friend Jai Dehadrai, who has written this illuminating book, and it's going to give us a lot to talk about this evening. I warmly welcome each of you, senior advocates, judges, ladies and gentlemen. We are delighted to have you here this evening. I really hope we will have a scintillating discussion on a topic which is of great national importance and cuts both ways. But before we get into that, I'd like to share with you some wonderful news of the EBC group. We've been talking to Microsoft, and on January 16, we entered into a formal partnership with Microsoft to develop a transformative AI engine and capability to take legal research to the next level in India and beyond. I'm very happy to announce this. And what I'd like to share with you is the common sort of shared, the values that Microsoft shares in this regard, and that EBC has had since 1942, right from the beginning. EBC, started by my grandfather and his brother, they had this commitment that we must do something for the nation. And I'm sure you all share that EBC has been doing this, and that is our commitment. It is this commitment that attracted Microsoft to partner with us in a big way to develop something that will truly transform not just legal research, but hopefully the adjudication and disposal of the gigantic backlog that we have. These are our hopes. Let's see what we can do. You will see it soon enough. Now, while I talk to you of cutting-edge AI technology, you might wonder, why are we still publishing books? You know, that there is some question that arises here. Well, the simplest reason for publishing books is to get you all here so that we can have a nice evening. That's the primary reason to continue to print books. But there is another slightly deeper reason, and that is our understanding of legal information and legal knowledge. It has been our enduring understanding now almost for 83 years. We are in our 83rd year. Right from the beginning, there's something special about legal information and what is required for adjudication of, say, disputes or the general purpose for which law exists, and that is for people to order their lives. That's the basic principle and the reason why law exists. So our understanding has been that you need to elevate legal information to the level of legal knowledge. And that requires a deep process of what techies call curation, right? We call it editorial work, they like to call it curation. And it is this underlying structure that exists in all of EBC's products in whatever form that we brought them to you over the last 83 years, this enduring commitment to curation, to structure, which is what distinguishes your experience when you are using any of what we produce, when you are in our environment and ecosystem. And that's why we feel, and will always continue to feel, that the book is the ultimate form of legal curation. It is the highest form of legal knowledge. You know, you may have judgments which may be analyzed with headnotes and digests and so on. You may have statutory law which is backed up with case law. You may curate in many different ways. But a book is where a trained legal mind, fine minds like so many of our learned authors and Jai here, what they do is, with their experience, with their training, what we may now start calling HI, with this incredible HI, we produce something and create books. So this is why we create books. We want to continue to create books, and I hope this will result in a very lively discussion this evening. And now to just touch upon the subject that we are going to talk about, and that is the prevention of money laundering. And this area of law really has to navigate a Scylla and a Charybdis. On the Scylla is the protection or the invasion of personal liberty that is sort of occurring or might be required to be balanced with something which can be a cancer. Cancer to what? A cancer to honest nation development. That's where it really comes down to. I know that a lot of our panelists are going to tear up this law and tell us how it's being used and abused and so on. So I don't want to make a case for the law. I just want to say that it cuts both ways. The Scylla is, of course, the unwarranted invasion of personal liberty, breaches of due process, and this is what we will be discussing in great detail this evening. But on the other hand, what does money laundering do? It is a cancer to honest endeavor. Because without public goods, you cannot create anything in civil society, or a civilized society for that matter. So if taxes are the basis of civilized society, those who don't pay taxes are freeloaders. They are a cancer on the hardworking honest. So that's why it's, and this is not go into the sort of crime, the organized crime that can only be supported through laundered money, right? So this is what I leave you with. And probably one of the most controversial areas that this law has sort of created is the protection or the lack of protection when a person is is arrested under this law. The Constitution says that if a person is arrested, they must be informed of the grounds of arrest in those 24 hours. And of course, the PMLA has these words in section 19, and amongst other challenges to the Act, this issue was also adjudicated by the 3-judge bench in Vijay Madan Lal. Now, I wonder what language one is permitted to use, but it is a radical judgment to say the least. It is so radical that 3 division benches of the Supreme Court have refused to follow the interpretation of the law. This very radical judgment actually says that you do not need to give the standard position of law, as we all know, is contained in section 50 CRPC, that you have to give the grounds of arrest in writing at the time of arrest. Otherwise, the arrest is illegal. Vijay Madan Lal says, no, it's not required. You just whisper in his ear why you're arresting him, and that's good enough. And it's even good enough that you never give him the grounds, give them to the remand magistrate. That's good enough. He'll decide whether it's okay or not. And it's only when the charge sheet is filed, 90 days of the extended period under PMLA, only then, because at that stage you must provide the grounds and the materials on which the charge sheet is based, then you can give him the grounds for arrest. 3 division benches of the Supreme Court have refused to follow that, and in different voices they have said either it must be given immediately, it can be redacted if required, but it must be given immediately or in the first 24 hours. So with these interesting issues which really affect our lives and our physical security, I hand over to our wonderful panel to illuminate us further. Thank you very much, and I very warmly welcome you, and thank you for being here.
Thank you, sir. I would now like to request Ms. Agam Kaur to please lead us into the panel discussion.
CD.
When Joeb would check, he would say yes. Everyone is calling ED. So when Joeb checks his mic, he will say yes.
It's working now. Thank you. Welcome everyone, all the dignitaries present off the dais and on the dais. I welcome my colleagues and my friends over here. You've gathered today for such an august event, and I would like to congratulate Jai for such hard work. Now, finally, we are seeing it through. Yeah. I would also like to thank EBC and especially Sumit Malik sir for giving me this opportunity to moderate such an esteemed panel of counsels, each of which are significant litigators in the field of white-collar crimes. Over the years, we have seen many gray areas that were there in this present act, that is the Prevention of Money Laundering Act. And Jai has taken a very successful attempt at penning down these gray areas into black and white in his book. Not taking much time, I would like to advance to our discussion today over here. And my first question is to Mr. Nadkarni to present his views, sir. So as we have seen that the Honorable Supreme Court of India has settled the principle that bail is the rule and jail is an exception. So how would you comment on this? Because we have seen that PMLA matters, the court comes to an exception to this, sir. Maybe please have your views on this.
Good evening. At the outset, before I answer this question, I would like to congratulate Mr. Jai Dehadrai for this wonderful work that he has done. It's an outstanding contribution in this field of law. I also thank Mr. Malik and the ABC for having given us this opportunity, especially me this opportunity to be here present today. Well, now the question which you have asked, that bail is the rule, bail is an exception, is indeed an old dictum which was laid down by our Supreme Court. That's because it emanates from Article 21 of the Constitution, which gives you a liberty, a life, to enjoy that life along with liberty. Basically, PMLA is an act which came into India much later. It came in other countries decades ago, few decades ago. It came in India only in the year 2004. This act was brought by BJP government when Mr. Vajpayee was the Prime Minister. But it was not implemented with that vigor. Mr. Manmohan Singh government, the UPA government which was there, thereafter amended it quite a bit. Mr. Chidambaram was the finance minister, and thereafter amended it, and they started, and it actual implementation started from 2014, when this present government, at that time, the first came. This was much required, because I do not think anybody will dispute in this hall also that there is no corruption in India. There is massive corruption. In this country, more controls breed corruption. But unfortunately, we only had the Prevention of Corruption Act. So if you have done an act of corruption, you go to jail. Most important thing is the wealth which you gather, the money which you make out of corruption, that was still being used by the whole, everyone at large. So to prevent that, the Prevention of Money Laundering Act was brought in. The whole idea is, you are not punished for the wrong which has been done by way of a criminal act of gathering the wealth, but for holding and laundering that particular wealth. That is why what is important is the proceeds of crime. But unfortunately, and I say unfortunately because most of our constitutional courts also have not seen this, that instead of the proceeds of crime, these people are being taken and lodged in the jail, and bail is being denied to them. The proceeds of crime is the money. It is somewhere which they have kept themselves, and they know it best. Nobody else would know it best. Now, keeping them inside, you are not going to gather the proceeds of crime. So actually, instead of putting them inside, you should take the proceeds of crime, and this criminal should be punished under the predicate offense. That is why in Madan Lal Chaudhary, the Supreme Court interpreted saying that if the predicate offense is not there, then you can't be charged for this offense. Now, once the Supreme Court, you must be aware, had struck down this provision about no bail, Section 45. In the same form, it was reenacted again by the Parliament. Now, it was for judicial interpretation, but unfortunately, the review of Madan Lal Chaudhary is awaited. But now, I am glad that Supreme Court and several judgments of Supreme Court they've come down very heavily, and they have now interpreted, and after that, the High Courts have started, granting bail, etc. But otherwise, you are absolutely right. There is no good reason why the general principle of bail is the rule and jail is an exception should not apply to this. That exception is only in matters like, POTA, UAPA, gangsters, international, all those kind of acts. So that is what I wanted to tell you.
Thank you, sir. So usually what is seen and what the government also argues in most of the cases is that why are these people apprehended for such a long time and put behind bars, is that there is a threat that because they have knowledge as where is those proceeds of crime being held, there's always a likelihood of that money being siphoned off. And also totally agreeing with you, sir, that scheduled offense, until that is proved, whether there is existing, whether the proceeds of crime is existing, is also questionable in those circumstances. So, sir, in this regard, how can courts attempt to balance the rights of accused persons and investigating agencies even prior to commencement of trial of the scheduled offense or the offense of money laundering, sir?
See, basically, as I told you, the proceeds of crime are not carrying with them in person. So you put them inside, the proceeds of crime are safe elsewhere. They've got enough people to deal with those proceeds of crime. The proceeds of crime are in safe haven, wherever they have invested or hidden or whatever it is. So it's for the government to go after these people and find out where the proceeds of crime have gone. And for that you have all your mechanism, you have your intelligence agencies, you have all kinds of, you can do whatever it is, the law permits you to go and, keep a trap on those people, etc. Find out that is how you have to take out the proceeds of crime, rather than simply putting this inside. Now, how the constitutional courts will balance it, of course, that's a judicial acumen. That's a very subjective matter. It can't be put to objective tests. In a given case, if a person is such that, he is simply he's born for laundering money, then of course, then those are exceptions where you can't. But one case where put people inside and they remain for 3 years, 2 years, etc. That is something not which can be countenanced.
Thank you, sir. On this note, sir, my next question is to Vijay Agrawal, sir. Sir, just continuing the present theme. Sir, what are your views? What will happen to accused who are languishing behind bars, or there's investigation which is continuing for a number of years? What will be the impact on the accused persons, or what will be the events arising therefrom?
The ED keeps everyone on leash. Once they come, they never go back. And it is like a snake and ladders game. The moment you finish everything, even then the snake bites you at 99 and you come to 0 again. See, we talk about Vijay Madan Lal Chaudhary and we say that bail is not there, or the power of arrest is there, or Section 50 statement is there. No, the biggest damage in that judgment is that they say, so people ask me that which is the most dangerous section in PMLA. I say it is not 19, it is not 45, it is not 50. So, the most dangerous section is Section 66, subsection 2. And they say that Vijay Madan Lal Chaudhary says that on one hand it said that if it is not related to the scheduled offense, ED does not have a jurisdiction, but it also gives the power to the ED to go and lodge a complaint to the police. So ED becomes the complainant. So I would say in 100% of the cases that I handle, once we feel that now the ED is gone and we've been able to save the party, scheduled offense is gone, or the PMLA bail has happened, everything has happened, ED one day gets up, makes another complaint in Section 62 and starts the wheel all over again. So though good for lawyers, the client also never goes away and the ED also never goes away.
Thank you, sir. I would also welcome Tushar Mehta, sir, here. He's here. Thank you so much, sir. Mr. Ghosh, I have next question for you. The Act prescribes for attachment of properties at the value thereof, sir. Can you please comment on where should a line be drawn while ED enforces its powers of attachment?
Can I also, like Mr. Nadkarni, first congratulate Jai and say why you are so lucky. And why you're lucky is because you have your loving parents sitting here and seeing your book release. When Sumit organized my book release, my parents were in Calcutta. So it was very sweet of him to actually get live streaming done, and they were sitting in Calcutta and seeing the book release. Another reason why you're lucky is, for my book release, one gentleman said he would come, but he did not come. But for your book release, I can see he's come here. Now, I was actually quite nervous because, I don't do too many PMLA cases. In fact, that gentleman has promised that if I am prosecuted under PMLA, he will protect me. Now, it is like a Bengali who can't speak Urdu, who has not only come to Urdu Mushaira, but he's being made to sit with Rahat Indori and the other great Sher Shairis and told to, give a share. So, why I am feeling less nervous is because I see a lot of non-lawyers in this audience. And for this purpose of PMLA, I'm also like a non-lawyer. So what is important to understand is, and you have to understand that normally book release is all lawyers speaking to judges, judges speaking to lawyers, but the consumer of the law is all of you. And if you think that PMLA doesn't affect you, it's only Vijay Agarwal and Mr. Nandkarni and Sanjay Ghosh and all facing Zoeb, the prosecutor, you are wrong, because these laws are meant to address you. I was going to say target, but then I've changed my mind, address you. So now, for example, coming back to the question is that attachment of property. Now please understand the whole concept of PMLA is what? That some illegally got money is being laundered. Laundry, the washing machine, launder. So it's laundering and trying to make it legal. Now in this process, the attachment is the first step. So a police officer will come and say your property is attached. It's a provisional attachment. Then there is a final attachment after hearing the issue. And then ultimately, if you are found guilty of money laundering, there's confiscation. Now, the problem is, and I'm putting in very layman terms because I don't know that much law as the experts here say. The problem here, and this is the problem, is the law says the money laundered or value thereof. So problem happens is that ED, which has to do the hard work to actually find the tainted money, is also given the soft option of taking any other value thereof or any other property. So what happens when you tell a child that you do a homework or you copy from ChatGPT, what will they do? The ChatGPT is the answer. So when you are giving them the soft option, the ED will only go for the low-hanging fruit, which is what? Which is some flat 15 years ago or some property which is 20 years ago, instead of going after the tainted money, instead of going after the actual amount which is gone. So to cut a long story short, and there are various judgments, the Delhi High Court has accessed all the judgments Zoeb will talk about. Punjab High Court took a different view. The Supreme Court has now taken a different view, Justice Oak's recent judgment. But putting it again in very layman terms, the thought is between two classes or two competing thoughts. One thought says that go after everything, because obviously you can't tainted, untainted, wo nahi kar payenge. Go after everything, jo milega wo le lo. The other view says that no, ED must first do its homework, find the tainted, and only if you can't find kaha chupaya hai, kaha tainted wala hai, only then you go for the untainted and attach the untainted property. And remember this is very important. And how it's going to affect your life, it is already affecting your life. Now, as home buyers, you will be asking for clauses to be put into your contract, their general law hum aa jate hain, where you will say, please say that there is no ED attachment, because any property, for any person can become an attached property. Let us say, I'll give you an example. Let us say a developer, one partner of a developer is caught in an ED project. That money has also come in the development of the whole project. Technically, the ED can attach the whole building as part of proceeds of crime. And then you as a home buyer will go running here and there. So that is a problem, which I think I've taken too much time.
Not at all, sir. This topic, in fact, requires a lot of time. I feel the more we talk about it, the less it is, because there's still a lot of work to do for us. And before I proceed with any further questioning, I feel there's a lot more to answer by Mr. Hussain over here.
Oh, God.
As while I was a legal consultant with the Enforcement Directorate, I also, while defending the department, I would feel that there are a lot of genuine questions as how would you decide, where will you draw a line between somebody's personal liberties and between protecting the case for the department till the investigation is ongoing and ultimate objective of achieving under the act, that is prevention of money laundering, because a lot of time passes away while the trial gets concluded. Even though there are a lot of third-party rights which are there. So how would you comment? Like, I would now bring everybody's queries towards you, like Sudeep sir stated, Mr. Agarwal, Mr. Nadkarni and Mr. Ghosh. How would you comment on that, sir?
Before I answer, thank you for considering me to be a part of this panel. And thank you for, when I was initially asked to join this panel, I felt I was reminded of in wrestling matches when you would have 3-on-1 or 4-on-1, it would be called a handicap match. So with some hesitation, I must confess, I accepted the invitation. But that is also because Jai and I go a long way back. The first time I encountered Jai was in a moot court competition which I was judging. And almost more than a decade back, he was a feisty young person and I scored him the highest. He ended up, he's become more feisty and possibly younger. I gave him the highest marks and I think he became the best student advocate. Thereafter, many years later, I find him as one of the most fierce opponents. I check my cause list on some days when I see that Jai is appearing on the other side. I say, please first bring this brief so that I can be doubly prepared because I know how sharp Jai can be in court. I've also had the occasion, I tend to read fast thanks to the number of briefs that Mr. Mehta marks me. So I've also had the occasion of reading your book, and I found your chapter. Two things that stood out in the book for me was your concern on section 3, that what happens to a person who is not aware that he's handling proceeds of crime, but ends up dealing with them, and how you have traced the entire jurisprudence on knowledge or mens rea to say that that is something that the ED must establish in trial by way of positive evidence, and that's a burden on ED. On that, I do feel that you're right. However, the law, as you are a more intelligent reader of the law and you've really gone into the plumbed the depths of the law, Section 20, there are certain provisions like Section 24 where certain presumptions come in, that if you have dealt with the proceeds of crime, it will be the burden on you to demonstrate that I did it in a bona fide manner. I'll give you a small layman example. A builder who is engaged to make a building for a gangster does not know that the money that he is receiving is from our proceeds of crime. He receives the money, builds the building, and he may end up receiving a notice under Section 50 to explain how have you received this money, what have you done with it. It will be on the builder to then show his bona fides that all that I did was have an arm's length interaction with him, and I've built this building, a turnkey project, and I've delivered it. 99.99% of the time, ED is not going after such kind of cases. It is only when there are shady dealings, when things are not being explained in a bona fide manner, that it is gone after. Now, to come back to your question, Agam, how the law is called Prevention of Money Laundering Act. Attachments are done prior to establishing whether the scheduled offense has taken place. Then how do you draw a balance between the rights of the people who are holding the property as against the interest of public that ultimately if he is found guilty, the property should be preserved. So the purpose of attachment, if you will see the definition of attachment as well in Section 2, subclause D, it is a prohibition on transfer, on conversion of the property, and on alienating the property. And if that is the intent, then it's clear that the only object is to preserve the property. Now, PMLA is not the first time this has taken place. The Criminal Law Amendment Ordinance of 1940 came in where Section 4 gave power on a district magistrate to attach property unless he has reason to believe on a bona fide belief that these properties are not involved in crime. So the value thereof is something that is there even in the criminal law ordinance way back in 1940. The scheduled offense in that ordinance is the IPC section 420, our Prevention of Corruption Act, which were inserted later. So therefore it is not a new phenomena. Secondly, if you see the Income Tax Act, section 281B to be more precise, if you see the Customs Act, section 28BA, if you see the Central Excise Act, all of those acts contained powers of provisional attachment to protect the interest of revenue during the pendency of final assessment. And this is a salutary provision because if all proceeds of crime, like Mr. Nadkarni lightly pointed out, the ultimate goal is to preserve the proceed of crime and to restore it to the victims. If nothing is left, if there is only a husk left behind, then what is it that the agencies are going to return to? So in this context, Vijay Madan Lal has in fact struck a balance. It is a part of the judgment which is in favor of the accused, which is rarely talked about, where the Supreme Court says, do not dispossess them unless there are very exceptional circumstances you find prior to trial. Under 8.4, they have read down the provision which hitherto said that the moment attachment is confirmed, you shall forthwith dispossess them. That provision is read down to say that unless there are very exceptional circumstances, please do not dispossess them. An exceptional circumstance will have to be tested on a case-to-case basis. If there is a person absconding, a proclaimed offender, or if the property itself is being used to commit further money laundering or other offenses. For instance, a property is being used for terror funding, then it can certainly be, a person can be dispossessed. There are two levels at which we analyze a law. One is the law and the other is how it is being implemented. And at both levels, there are judicial corrections. And that has happened over a period of time. And I think it is always a welcome step. And there will be a little bit of back and forth between the executive and the judiciary. I thank you for your time.
Thank you, sir. With your comments, sir, I believe that our audience will now feel that the present act that is there, that is Prevention of Money Laundering Act, is not as much draconian as is generally portrayed. There are a lot many safeguards also under the act, and as an investigating agency, as third parties, or as judiciary, there is onus upon everyone to ensure those safeguards are implemented alongside these persons who are laundering money, getting nabbed, and money going to the rightful sources and not being laundered or brought into the economic channels. My question is now to Mr. Agarwal again, coming back to you, sir. Sir, from your practical experiences, can you please share the difficulties faced by third parties such as chartered accountants and in-house legal advisors when they come under the radar of ED?
Problems are faced by external lawyers also. See, the client gets arrested, his whole office will come to us. They will have his legal counsels, his staff, HR manager, and everyone will come to our office. And then what I'll do is I'll make a WhatsApp group that whatever information you have, you start sending it to me. Then in what matter it so happened that, 5-6 gentlemen come, they say that our managing director has been arrested, and I am the HR head, I am the CEO, I am the legal head, I am the company secretary. So I said, okay, fine, start sending me the documents, I make a WhatsApp group. The next day I realized that, each one is exiting the group one by one. I said, what is it? I'm getting debriefed. Then I realized that all of them have been summoned by the ED. Then first of all, they asked him that who is the lawyer, whose group are you on? And when they seized his mobile phone. So you please see that, when you are dealing, if a client gets arrested and a client is there, you never know that who will be summoned. In a FIR, generally you know that these are the name of the people who are the accused. ECIR you don't have access to, and ECIR is nothing but copycat paste of the FIR. So anybody who is dealing in the company, of course you will have his family, you will have anyone. Suppose the son, the MD gets arrested, his son comes to you for advice. But tomorrow you do not know that the son may be called. And ED itself says when a person goes to the ED office, he is not an accused till the complaint is filed. So anybody who's dealing, whether the legal head whether the chartered external lawyer or whether the chartered accountant, everyone is at risk. So as Zoeb just pointed out, and I was about to say, it is so beautifully dealt by Jai in his book. Suppose the client is paying fee to a lawyer. The lawyer knows that the client is for a money laundering. So what he does. So you please see that this WhatsApp incident that happened with me personally, that shook me. And see what is the plight. I mean, and then I realized that whosoever goes to meet the person in jail or to give him food, when a person is in jail, a person is supposed to, his family or his officers are allowed to meet him twice in a week. And they can pass him over some clothes or anything. You can't pass oranges because you can hide something in oranges, right? But the other things you can pass on, fine? So then I realized that everyone who goes there, next day is summoned by the ED. And then they had no one. Then I said, okay, when I'll go to legal mulaqat, then I'll carry your clothes. So the problem is that, you never know that anybody in the company can be summoned. So when anybody is summoned, he can make any kind of a statement. So you are not sure that the person that you're dealing with is an accused or is a witness or anything. And you talk to them, then you never get bail because then the allegation will be of tampering. So that's the plight. But I'm not blaming ED. As I said, that is all right. But this is the problem, the way the fault is. And see, of course, ED officer is not a magician. Of course, he has to investigate. He has to call people. But somehow there has to be a distinction that when the company's officer or anybody is dealing, he never knows till the last moment that whether he's going to become a witness or is he going to become an accused. He's always on a borderline.
Thank you, sir. Mr. Nadkarni, on what Mr. Agarwal has just deliberated upon, in many cases we have seen, like he's saying, that people come to lawyers for advice, and there is a principle of confidentiality between them. Similarly, there's a principle of confidentiality between financial advisors also. So many a times we have seen the properties of financial advisors and lawyers getting attached in such matters. So what are your comments on it?
Frankly, I'm not aware about properties of lawyers getting attached. If they have dealt with the client's matter, I'm not aware of that. I'm not aware. Insofar as financial consultants are concerned, under the Income Tax Act, a chartered accountant has a criminal liability if he files returns knowing that these are false returns. Unlike for a lawyer, when he argues a case, there is always a presumption of innocence in favor of the accused. The experience which Mr. Agarwal has, of course, I'm sure he has rich experience than all of us in dealing with the matters because he deals at a different level. We deal at a different level. So I did not find any lawyer's property being attached of, I don't think Mr. Zoeb Hussain will be the best person to
I have seen like in-house counsel's properties getting attached because they had given certain opinion during a transaction being happened. So
no, that is, if they are part of the whole system, I mean, as an accused, right?
In fact, sir is right. Section 126 of the Evidence Act has an explanation.
Explanation, correct. Because that's a privileged communication.
An experience,
privileged communication.
Yes, sir. Definitely.
Unlike under the Income Tax Act where a chartered accountant has a liability.
Thank you, sir. My next question is to Mr. Ghosh, sir, on similar lines. As I would also like to know your comments and your experiences as how can investors who bona fidely invest into entities which later get caught under the radar of ED, how can investors, financial institutions who have already spent huge sums for certain projects which were promised, and later on an ED investigation happens in respect of a particular company, so the bona fide investors, bona fide bankers, bona fide financial institutions are caught in the entire hurricane of investigations.
Audible?
Yes.
So
Yes,
a quick answer. I just wanted to, though you asked the question to Vijay, let me tell you that it is not unknown that lawyers are also harassed in ED. My classmate, I'm from the National Law School, Bangalore, a senior to Sumit. My classmate, I don't want to mention his name, he was engaged by a very reputed law firm of Delhi to do a legal vetting of a property years ago, 5-6 years ago. Recently, a year back, he received ED summons and he was made to sit for 9 hours at the ED office in Chennai and ask question after question as to on what basis was this done, who paid the fees, why did you give this? It was a simple property search report. So lawyers are also harassed. It's not that lawyers are not harassed. Now, coming to your point, there's no point getting into nitty-gritties, but the more importantly, and let's deal with the elephant in the room. Why is it that there is a problem in our society? There are plenty of laws. And a great initiative is taken by the Honorable Prime Minister saying that we have to reform and finish off all these old laws. How many laws this present government has deleted? Useless, old laws. But one important thing, and I'll request the government to also consider, while deleting old laws, also put in a system of auditing existing laws. That is, every law should have a legal audit as to how effective that law has been. And that should be done very periodically, every 1 year or 2 years or 3 years. Similarly, in ED, this PMLA, there should be an audit done, and not as and you have these as they say in Hindi, aakde coming out. So many amounts have been attached. But the success is not attachment. You see, attachment is the beginning. As Vijayji was saying, that is 0 and then 99 and 100. Ludo means the snakes and ladder, you have to go to 100. So the success is ultimate confiscation of the asset. And the more importantly, and to tie down to your question, after confiscation under Section 8 to release it to the parties whose asset it is. So let us do an assessment of this law. There are so many arrests being made, so many attachments being made. How many confiscations have finally happened? And how much of that under Section 8.8 has been returned to the parties, to the banks, the financial institutions, etc. And we will be surprised as to, no one should be guessing as to what the results will be. Therefore, it is important to also, with this audit, put in place systems of, and this is a larger issue, of our legal system. To have, if you want to have an ED system where you have to be jail, and bail is not the rule, presumption of guilt, then you must have more judges and you must have efficient trials, finish the trial in a year or 6 months, 7 months. So this is a very large issue. I don't know what we can do, but it's something which really has to be done.
Excellent suggestion, sir. I feel time is of the essence because everything comes down as people languishing in jail, properties getting attached, money being frozen in accounts of people we whether know is a laundered amount or not a laundered amount, but being stagnant, personal liberties being stagnant and finance being stagnant for a long period of time is not great for society. Therefore, I think the best will be to expedite trial of schedule offense connected with trial of the offense of money laundering. Both things should be expedited as much as possible while not sacrificing on the evidence that is gathered during that process. So with this, I'll make a slight shift to what we've been discussing as of now and move my next query to Jai. Jai, can you enlighten us as to instances where lookout circulars are issued against persons and how it can be an effective tool or weapon in the hands of investigating agencies?
Thanks, Agam, and thank you everybody for being here tonight to celebrate my book. And to the learned Solicitor General, thank you for being here, sir. My senior, Mr. Nadkarni, Honorable Justice Geeta Mittal, who's also here, my parents, of course, Mr. Sanjay Ghosh, thank you for those very nice sort of remarks that you made, and of course, Zohaib Bhai, thank you, and Vijay Bhai, thank you for being here. Agam, the point on LOC, this is what I feel, that much like personal liberty is very important, and we heard from Mr. Nadkarni and from, of course, Mr. Ghosh as well about how many individuals charged under PMLA offences languish for years and years together. There is another element to this as well, which is where you are not actively incarcerated as a pre-trial prisoner who's been charged under the PMLA. But the other element is that while you may have your liberty intact, many a times as a coercive tool, you are not allowed to leave the country, or you're not allowed to travel freely if you so wish to. And this is where LOCs come in. So these lookout circulars, which are typically used by investigating agencies as a means of ensuring that a person's presence is assured, and that that person doesn't leave, the territory of a country to evade an investigation. We also find situations and instances where LOCs are issued just as a coercive measure to trouble someone, which is what you rightly described. That is it a tool for investigation, or sometimes can it also be turned into a slightly more sinister weapon to compel a person to remain within the country and to not travel unless and until they give up certain information. So that is one aspect to it. And I think it also goes against the notion that we all have, that there should be honest field work by investigating officers to get to the bottom of whatever case that they are investigating. So from that perspective, yes, I think LOCs should be used for the right reasons. In fact, I did a very interesting case just this last weekend. I won't disclose any specifics. Sorry, am I audible? Yeah. I won't disclose any specifics, but just this past weekend, I got an SOS phone call from a client and a friend that there was a doctor, a very celebrated doctor, flying in from London who had been stopped when he landed in Bombay. And the issue actually pertained to an LOC that had been opened against him in the year 2019. And he had come to purchase certain property overseas, and the allegation against him was that the property had been bought from someone else who was being investigated under the PMLA, and therefore he could potentially be a benamidar. That was the allegation. That was what the investigating officers who were questioning him were hinting at. So, of course, he was able to show that his sources of income were absolutely clear, that there was no question of of him being a benamidar holder or a name holder for this entity. But despite that, he was grilled for 6 or 7 days continuous. And finally, of course, our courts, and one, of course, must acknowledge the role of our constitutional courts, no matter what the compulsions of our prosecutors, and Zohaib Bhai would understand that, of course, he must act under instruction. But our courts have been fair, and by and large, they have always come to the rescue of any person whose liberty has been questioned. So in this case as well, back in 2019, this client of ours, he was able to get permission to leave India, and being a UK citizen, and he had patients to operate, he had patients to consult. So he left the country in 2019. But this time when he came back, almost 6 years later, 5.5 years later, they caught him at Bombay. So it turned out that earlier LOC had been closed, but a fresh one had been opened thereafter, soon after. So he was again taken in to very politely, of course. I mean, EDs are very civilized. I mean, they treat people in a rather civilized way, most people. And he was taken into the ED office in Bombay and questioned. His lawyers immediately moved the Bombay High Court, and another very celebrated lawyer, Mr. Manashinde, he appeared, and immediately he was, the ED was directed to question him, to ask whatever questions in a time-bound manner, and his liberty was restored. He was given permission to leave the country. So I think for me, and in my experience, it all boils down to a balance. I think what Mr. Nadkarni said earlier about the necessity of this law, nobody denies it. There is widespread corruption, money laundering, unfortunately, in this country, and it has been so since the last 60 odd years. But this government is serious about cracking down on it. But at the same time, there has to be some sort of I think there's a problem. There has to be some sort of a balance. There has to be some sort of a balance between incarcerating, people who are not guilty of these offenses and taking away their properties. So I think that's a fight that is constantly going on, being waged in our courtrooms. And our judges have always risen to the occasion, in my view. In some cases, well, maybe the law itself acts as a handicap. But in most cases, I think there is a sense of fairness.
Thank you, Jay. Mr. Hussain, could you please comment on this particular scenario? So even in experience of Jay, and even I have experienced in certain circumstances, certain entities, persons who are not accused persons, lookout circulars have been issued, and they are restricted from traveling abroad, or they are caught hold of while entering into India, and they do not have any direct linkage to the main offense. And in these circumstances, courts definitely come to the rescue. So what can be better done as far as investigating agencies are concerned? Because I understand strengthening the case is vital and paramount and should be kept above everything. But shouldn't a call be taken in order to balance as who should be caught and be put behind bars, where the other person should be restricted? How do we see that, sir?
So lookout circulars can be issued at two stages. One is at the stage of investigation to ensure that the persons required for investigation do not leave the country. And the other is, if someone is already abroad, to ensure that if he lands up in the country, to secure his presence during trial. At the stage of investigation, as you are aware, material may be sketchy, but some role has emerged and therefore lookout circulars are issued. I'll give you an example as a case study. When I was appearing in a matter, and it was a scam of around 1900 crore, where the concerned individual had cheated large number of investors, taken away 1900 crores, and had lavish mansions in Malibu, had nightclubs abroad in New York, and was hoping to go away. So one of the things that investigating agencies as well as courts consider whether a lookout circular should be upheld or not is the ability of a person to sustain himself abroad. Now this gentleman, and the only reason why this, even all the way up to the Supreme Court, this gentleman was prevented from traveling, is because during arguments we were able to show that the people who have been cheated were begging him for money for their health and for operations of their parents, and he was not denying them even a single penny. Now, the law has to be tested on balance, as my learned friend Mr. Jai is right, but you have to see the entire spectrum of cases where powers are exercised. Supreme Court has laid down serious guidelines on Section 19. The recent judgments have said that you must not go ahead and arrest every single person who you find reason to believe that he is guilty, but there has to be necessity to arrest. For that, there is some parameters to be taken from Section 41 of CRPC. That is, if you find that he is continuing to commit the offense of money laundering, or that if his arrest is going to aid the investigation, or if he is likely to tamper with evidence, then a person is arrested. Now, your initial question, he is arrested, but he should be granted bail the moment you file charge sheet. But then this was heavily debated in the Supreme Court in the judgment of Vijay Madan Lal. There are certain kind of laws that the Parliament intends to be dealt with strictly. Makoka, NDPS, all these laws have twin conditions. Even if you see 437 of the CRPC, it says that a person will not be released on bail if there are reasonable grounds for believing that he is guilty. And it is not a new formulation in PMLA. It is a different matter that in certain cases, in certain individualistic cases, there may be cases where the bail law has not been correctly applied by some courts. However, the larger view that PMLA is an offense, which is a very serious offense, cannot be denied by anybody, and therefore stringent conditions of bail are there. But if for some reasons not attributable to the accused, the trial has not progressed, the courts have said that we will release you, and it will be an additional condition read into 45. So there is now a good, very healthy development of the law, where courts have softened the rigors of law. Officers who take the view that reasonable grounds for believing that someone is guilty are now a little more responsible. And therefore, let us hope that the law will shape up in the correct way. My learned friend, Mr. Ghosh, just pointed out that how many confiscations have taken place. Even pre-confiscation, properties which are attached can be restored to the victims under the further proviso of Section 8.8. And to my knowledge, last year alone, around 30,000 crore rupees was restored back to financial institutions and banks, which is probably the largest amount in independent India. Thank you.
These are very helpful thoughts from your end, and it clearly shows that there is a very well-aware thought process that is taking place on behalf of an investigating agency against which fingers have been pointed out time and again. And we cannot see secluded events where misuse of powers have been there and they have been publicly portrayed or flashed again and again just to show that there's an investigating agency not doing as much work as it should have is a wrong perspective. We should see a picture at large, and we should see and commend officers also who've been doing their work, because it's not an easy act to catch hold of an intelligent accused person who has ensured to cover all his tracks and roped in innocent third parties while doing so, and covering and hiding proceeds of crime and basically laundering it into different channels of our economic system. Thank you so much, sir, for enlightening us on that. And I would also welcome Justice JK Maheshwari, who is now with us. So thank you. So last question to you, Jay. Just wrapping up the theme, we have also seen that while letter of request, various properties have been attached abroad. How do you see, sir, how our rights should be safeguarded in those circumstances? How, if there are certain properties which are attached as proceeds of crime, which is clear, the rights that have the exercise of powers is rightfully used, but what if they are undervalued thereof? How would you comment on that?
I'll be very brief because now, of course, the Honorable Judge is here, and I'll be very quick and try and answer that. See, as far as foreign properties are concerned and which are attached by the ED, in my experience, I've seen that even individuals with whom there is no direct link to the proceeds of crime, even their properties come to be attached sometimes by projecting them wrongly as benamidar holders of such properties. But I think there is a safeguard to that. I should not be entirely critical. The law permits it, but the safeguard is that there are reasons to believe that have to be recorded and then tested subsequently. They can be tested before the adjudicating authority, and subsequently, of course, they can also be brought before the High Court or the Supreme Court and tested there. And there are multiple judgments now of our Honorable Supreme Court which have laid down this aspect, that unless and until there is a proximate nexus that connects such proceeds of crime to the assets that are sought to be seized, you cannot seize just anything. So I think the courts have again come to the rescue of individuals who are able to demonstrate very clearly that their assets have been wrongly seized. So I think the balance is there, and I think the courts again come to our rescue. Yeah.
Thank you so much, Jay. And I would also like to thank all the panelists here who have shared their thoughts, and Mr. Hussain especially, because he was the only man on his team defending ED. I would congratulate him specially. Now I would hand over to Prachi for leading us ahead in this session.
Thank you, Agam. Thank you all for this incredibly insightful panel discussion, and I'm confident that the ideas shared today will resonate beyond this room. Let's carry this momentum forward, and I would like to invite our esteemed Chief Guest, Justice JK Maheshwari, and Guest of Honor, Mr. Tushar Mehta, on the dais for the much-awaited book release. I would also like to invite Justice Geeta Mittal and Mr. Sumit Maheshwari book release on the dais. That was truly a magnificent sight to behold. Once again, thank you to all our panelists for that lovely panel discussion, and I would like to request you all to please join us on the sofas. Yes, of course. It is my honor to introduce our chief guest for the event, Justice JK Maheshwari. Born in a small town named Jora in Madhya Pradesh, Justice Maheshwari began his legal career as an advocate, practicing in various courts, including the Supreme Court and the Madhya Pradesh High Court, before being appointed as an additional judge of the Madhya Pradesh High Court in 2005, and later ascending to the role of Chief Justice. Notably, Justice Maheshwari became the first Chief Justice of the newly established Andhra Pradesh High Court, where he championed the establishment of Gram Nyayalayas across the state and also impressively disposed of over 4,500 cases in just 15 months. In 2021, Justice Maheshwari was elevated to the Supreme Court of India, where he continues to make profound contributions to the legal landscape. We are honored to have you here with us, sir. We also have with us our esteemed guest of honor, Mr. Tushar Mehta, the second longest serving Solicitor General of India. A beacon of legal expertise, Mr. Mehta's journey began at Gujarat University, where his brilliance shone through as he earned 5 gold medals while obtaining his law degree. His career took flight in 1987 as an advocate, and just 2 decades later, he was designated a senior advocate by the Gujarat High Court at the young age of 42. In 2008, he took on the role of Additional Advocate General, and by 2014, he was appointed as the Additional Solicitor General of India. His dedication and commitment culminated in his appointment as the Solicitor General of India in 2018, a position he has held with distinction. We are honored to have you here with us, sir. I would like to request Ms. Bhumika Indulia, Senior Associate Editor, EBC, to felicitate Justice Maheshwari and Mr. Mehta. It is now my privilege to invite Mr. Tushar Mehta to the stage to share his thoughts on this momentous occasion.
Honorable Mr. Justice Maheshwari Sahab, the bridegroom of today's function, Mr. Jai, my dear friend, and an excellent author. I have gone through the book, and I can say that it was very balanced and unbiased book, one of the few. My very dear friend, Mr. Nadkarni, my dear friend Mr. Zoeb Hussain, my very dear friend, one of the few lawyers who have the sense of humor, Mr. Sanjoy Ghosh, I'll not mispronounce your name, Mr. Agarwal, and friends. When Zoeb said that it is a wrestling match where we have a handicap, I would add something. In ED cases, the other side has what we call as fight without any rules, and we are supposed to tie our hands to our back and fight. And I'll explain why and for what reason. But since most of the faces are good and decent faces and very few lawyers are in the audience, I would like to show why this law is necessary. Mr. Ghosh wanted to say that this law is to attack you, but then being an intelligent lawyer as he is, he said it is to address you. And it is really so. First of all, how this word was coined, money laundering. There was a Don in US, Al Capone. He amassed huge illegal, illicit wealth. Now, there is a limit of storing your wealth physically in a cupboard or in bank account, in bank lockers, etc. So he planned a new device whereby he started several laundries in the entire United States. And it's a fact. That's how the money laundering comes. And if you go and get your shirt washed, it would be 5 rupees, but he would show the receipt of 50 rupees. So the black money started being converted into white money. That's how the word came, money laundering. Now, before I come to why it addresses you, the real common man for which the law is intended, let me tell you why the law was needed. But before that, there are two statistics I would like to give. There is an impression which is created that large number of indiscreet arrests are taking place in case of money laundering. But let me inform you, it's an act of the year 2002. We are 22 years down the line, and the total number of arrests since 2002 till date is not more than 350. As Zoeb has already said, the laundered money which the ED gets is supposed to be returned to the victims of the offense. Mostly the victims are the banks, and the real victims are the depositors or the customers of the bank. And at least in the last year, 30,000 crore is returned to the banks by the Enforcement Directorate. The difficulty is, there is a story of a hen and a duck. When the hen lays the egg, the entire area comes to know that the hen has laid an egg, because it would roam around the entire building, quack, 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 quack. Everyone would know that the eggs are now laid. While a duck would lay the egg and sit quietly. The difficulty is, there are draconian laws in this country and used in a draconian manner, but this is the only law which targets those who are powerful and influential, both financially and politically. They have the wherewithal, they have the entire ecosystem. And a narrative is built through private YouTube channels, through delivery of lectures, through press conferences, and ED, the establishment, can never counter this narrative, and unfortunately, that narrative has started affecting the process of law. And therefore, it is necessary for you, the citizens, why this law is necessary and why the government is doing its best to protect it. Friends, money laundering is not an act or an offense which is troubling India. It's not only Indian specific phenomena. The world is facing this problem and there is no denying about it. The world realized this problem and tried to find out a solution at a global level, because here my money can go to some heaven, what they call tax haven countries, and I can park my money anywhere in the world. So this cannot be an India-centric law. You must have a framework which is a global framework. And therefore, under the United Nations, all countries which have the financial wherewithal and which are economically progressive nations, they got together and decided to have what is known as Financial Action Task Force. India is a member since 2000, and whenever the Financial Action Task Force was constituted, it's not that this is a recent phenomena. Now, when you are dealing with a global phenomena, an offense which is globally being committed, you must have a uniform pattern of law. My law cannot be different from the law in USA. My law cannot be different from the law in England. So therefore, they came out with 40-point guidelines that every law will have to have these 40 parameters in their respective countries' legislation. That is how the law came to be passed by Indian Parliament in 2002, much prior to 2014. Now, how would you decide that this law is being implemented in a manner in which it is intended to be? That this law really meets with the global standards and it is not diluted by one member country of that international convention. There is a system, the system of what they call peer review. Peer review would mean that 5 members of 5 different countries would come to India, would go to America, would go to Japan, would go to all other countries, different 5 members. And they will see 2 things. A, whether your legislation is in conformity with the international standard which is laid down or not. And B, whether your implementation of that law is as per the global standards or not. And if we fail, what is the consequence? The consequence is devastating. The Financial Action Task Force, in its peer review, which is done periodically, will give gradation to each country. You are in a grey list or a black list or a white list or other list. And if you go below a particular level, nations' capacity to take financial assistance from World Bank or Asian Development Bank goes. The nation's eligibility and the credit rating in the credit market, in the international global market, goes down. It directly affects the economy. Now, please remember, you must be listening and reading in newspapers that one boy was picked up. Though he was a juvenile, he was treated as an adult. And ultimately, at the Supreme Court level, he was acquitted because he was, in fact, a juvenile. There are a large number of such cases, but they are not spoken about. There are a large number of cases where innocent people are being persecuted, prosecuted, jailed. But this is the law which affects, impacts, and touches those who are powerful. And it hits where it hurts the most, namely their economic system. That's why a narrative is built. Nobody would argue, and if somebody were to make a survey or a research, maybe the people who are not juvenile and being tried as juvenile, or vice versa, people who were juvenile and were tried as adults and convicted would be much more than those who are convicted under the economic offenses, like money laundering. But they would be concentrated. There would not be any any system of creative a narrative, building a narrative that something is going so drastic. I can't give facts, I can't give illustrations, but even in those cases which prima facie as citizens you must have thought to be political, Zoe would bear me out, when we found the cash, we were running short of cash counting machines. We had to borrow and bring more and more machines for counting cash. But the narrative would be built that because A, B, C, D, political, etc. reasons, that the person is being persecuted. But ultimately, the ED officials are human beings. They have all human follies, which each one of us have, lesser degree, higher degree, depends upon the circumstances, depends upon the upbringing, etc. And there may be certain cases where there may be abuse, there may be misuse, there may be overuse of the provisions, and that's why there are courts. But to classify a particular act or a particular agency as an oppressor merely based upon the narrative which is built either for professional reasons or for political reasons may be a little unfair to the nation, may be a little unfair to the efforts being made at the global level to control this menace of money laundering. And mind you, there are countries where you can buy citizenships and they will never permit extradition. There may be instances where the courts may find that here preventing somebody from leaving the country was little harsh, and the court is the ultimate arbiter. But I can't name cases, but people have, when the matters were pending before the court, after assuring the court that they will not leave, have left this country and are staying in islands where they have bought citizenship. If there are concerns, concerns must be addressed. Human beings are not gods, and therefore we have the system of court. If my fundamental rights are violated, it would be taken care of, it would be protected by the courts of law. So far as Jai's book is concerned, I'm really happy to know that apart from the brilliance, apart from the scholarship which has gone into preparing this book, this is a book which is a balanced book. It neither scolds the enforcement directorate, does not unnecessarily criticize the act, and at the same time, it also ensures that the fundamental rights of the citizen, even while this act being implemented, are protected and how to protect it. This is one of the few literary works which I have come across, and I would really congratulate the parents of Jai that you should be really proud of your son. We are proud of our friend, and you should be really proud that your son is a brilliant lawyer and now a brilliant author. So far as my dear friend Mr. Agarwal is concerned, his concern was that even professionals are troubled. I can assure him, based upon my experience, that so long as you remain an advisor, you means any lawyer, there is nothing to worry. If you were or you are an accomplice, then merely being a professional is no ground for you to seek a special treatment. Friends, I am thankful that I am sharing the dais with a legal luminary like Justice Maheshwari. I am thankful to the organizers and especially my dear friend Jai that I got this opportunity to be a part of this august gathering in this momentous occasion. Thank you very much and good night to everyone.
Thank you, sir, for your insightful address. I would now like to invite Ms. Maheshwari to share a few words with us.
First of all, I will say sorry to everyone because I was late enough to come. Because though I gave a time that I will be here by 5:30, but unfortunately because of my flight from Udaipur was late and I could not come well within the time. First flight was cancelled, then I took a 5 o'clock flight. So because of this I am late. I've heard very little. First of all, I address Mr. Solicitor General Tushar Mehta ji, Malik ji, Jai and publisher. Panelists are sitting, Mr. Natkarni, Agrawal, Joy and Ghosh ma'am, Geeta Mittal, and dear advocates, gentlemen who are present here, Agam who did the Herculean task to have this moderate the issues. I already said to Avikal that so far as discussion part is concerned, I may not be a part of it. Because all the issues are coming every time. So I may not be in a position to say either side, this way or that way. Then issue come about the work done by Jai Anant. So far as Genesis objective PMLA is concerned, I would like to say something, but Mr. Tushar Mehta is absolutely right. The basic behind of this Money Laundering Act was that the act in the USA, but the only thing was that what we have to do, that Bank Secrecy Act came in 1970. The attention was not thoroughly done, though this was discussed in that Bank Secrecy Act. There I durust hai, I will say, for this legislation. The region of this legislation to bring was that we were the part of the treaty, and Jai has rightly said that the history of Hawala is parallel system of the money transfer, which reminds us to these formative developments in financial crime enforcement. It also calls to mind of the United States post-depression era of 1930. That was the time in which this laundering issue has come, and the money was parked in the same way as it was described, need not to say again and again. Then to check these mafia activities, this law, it was decided that there must be a law for this laundering, and therefore this law is there. We have to say in a different perspective that assessment of the PMLA safeguarding India's financial landscape. We have to work on this only. If we look into, I will say that this act came in 2002. Enforcement started whenever it is not relevant. But the purpose of the act to which it was brought, that in shaping of the contours of the enforcement of the judicial proceeding in India and prevent money laundering. Investigating agencies were equipped, work started, search was done. When it will be done, during process of investigation, so many things comes this way or that way, we will not comment of it. But when it comes to the court of law, then the procedure ought to be examined in a right perspective. And if in this way, if we look into how the book act upon and how the book, what work has been done in the book, then if we see the entire gist of that book says the PMLA has evolved a powerful tool for law enforcement. It says, however, as with all laws of significant reach and impact, its implementation must strike a delicate balance between effective enforcement and the preservation of the constitutional right. Tushar Mehta Sahab said that this is a balanced book. I say in a different perspective. If I would like to find out something in the book and to search on any particular topic, I will get it, I will pick up. For the purpose of the interpretation of the provisions of the Act, it may be of Section 19, it may be of Section 24, whatever it is. Then we have to examine with the touchstone of the fundamental right as enshrined by the Constitution and Article 21 of the Constitution. If we go with all these aspects, I will commend one thing to the work of Jai Anant. This boy did a miracle while writing this book. I can say this. I have gone through this book. Usually I don't agree for this function, but I said, please keep it with me. Avikalp came to me. When I keep it with me, I will look into. I assigned to my 2 law clerks, and then I discuss with them what is there, what is not there. Subject-wise, when I made my assessment for the book, then I was happy, and I should say agree. Yes, I will be a part of it, though I denied that I would not be a part of your panel. So I commend this, I congratulate, and I say for our institution, it is a good book, it's a book of help to everyone, and it is useful even for general public, and without criticizing anyone, we can say whenever the issue comes, we can take guide from the topics as specified in this book. I say Mr. Malik has taken a right step to publish such a book, and that is thorough. And in particular, it is having instinct of that section, interpretation of the law on the topic, and how it can be dealt with. Then how you can test with procedure is right or wrong in the touchstone of the Constitution of India. I will say in closing, for PMLA, I will say it is a cornerstone of India's legal framework because we have to apply it, and for financial crimes, we have to look into. Its provision empower the state to combat the grave threat of money laundering while aligning with the international standards on evolution of this law. It is imperative to address its challenges and to ensure that its enforcement remains fair, impartial, aligned with constitutional principles. And finally, Jai Anant's book I would like to congratulate to the parents also, but the parents have gave unko sanskar diya, it's fine, but this boy did a miracle, I say again, and it is a nice book, and it is for ever. Thank you very much for calling me, and for this, in this occasion where we are saying this book would come to our legal framework. Thank you very much.
Thank you, Justice Maheshwari, for your compelling address. It is now time to hear the man of the moment, and as Mr. Mehta said, the bridegroom of the event, Mr. Dehadrai.
Thank you. It's a tough act to follow when you're following a judge of the Supreme Court of India and the Solicitor General. It really is a tough act to follow, but I'm going to try and I'll be brief. But sir, thank you so much, Mr. Mehta, sir, for your very, very generous praise for my book, and Honorable Justice Maheshwari. I don't think I could have asked for finer endorsement of my book, and I'm truly very grateful that you have endorsed my book. So thank you, sir. Honorable Justice Maheshwari, of course, Judge of the Supreme Court of India, the learned Solicitor General of India, Mr. Tushar Mehta, my senior, Mr. Sushant Nadkarni, former Additional Solicitor General of India and former Advocate General of Goa, Honorable Justice Geeta Mittal, former Chief Justice of the Delhi High Court and of Jammu and Kashmir, Mr. Sanjay Ghosh, my friend and senior advocate, Mr. Vijay Agarwal, leading criminal lawyer, Mr. Zoeb Hussain, the senior standing counsel. I have to address everybody, so, senior standing counsel for the Union of India and someone I spar with on a regular basis, but the thorough gentleman that he is, no matter how heated things become inside the courtroom, never once does he make me feel that he's anything less than a friend outside the courtroom. My friend and publisher and the director of the Eastern Book Company, Mr. Sumit Malik, my parents Anant and Ratna Dehadrai, and my dear friends in the audience, thank you all for taking out time from your very busy schedules and for coming to join us for the release of my book today. With the legal giants in this room, I feel very inconsequential to say too much, and I will thus try and keep my remarks very brief. I would like to share only two stories with you. One, how this book came into existence, and second, what drives me to practice law every day as a litigating lawyer, mainly on the criminal side. And I suspect that some of these feelings might also resonate with most of my very respected colleagues who are present here today. I know that some of the very respected members of our audience also are not lawyers. And I hope to give you a small glimpse into our world and to show you what occupies our imagination and also the challenges that inspire us to do our work. First, I want to quickly tell you how this book came to be published and what I seek to achieve with it. When I first started doing PMLA matters a few years into my practice, I felt the need for a simple-to-read primer on this fairly complex subject of law, something I could keep on my desk for ready reference, with an easily accessible list of latest cases and easy-to-read chapters organized thematically. As I was unable to find such a book, I decided to write one. My aim was to simplify the subject for any practitioner, be it a lawyer, an honorable judge, an investigating officer of an agency, who might need to quickly access reliable explanations to this fairly new law. I wanted the guide to have clear and simple to understand language with direct references to the key case laws that deal with each aspect. My lawyer friends will appreciate that adding a table of case laws was a clever move on my part to ensure that my publisher, Mr. Malik, has no choice but to keep coming out with updated editions every year. Once my draft manuscript was complete, like any lawyer, my dream was that the best law publisher of India should find it worthy of being printed under their name and banner. With that hope, I immediately sent an email to Mr. Malik at EBC, imagining rather optimistically that his directors would jump at my book and sign me on like a celebrity author, much like we see in the movies. But we all know that life is seldom like it is in the movies, unless you have followed my life closely over the past year or so. That was in a lighter vein, of course. But I was thrilled when Mr. Malik wrote back to me. He was very polite and polished, as he always is, but he refused to publish my book. He said that he had another book on PMLA, which was already in the pipeline. But those of you who know me also know that sometimes I can be quite persistent. I was very sure that only EBC and its experienced team of editors could do justice to a contentious topic like the PMLA. I wrote back to him and asked him to reconsider his decision. And after a very long month, when I had virtually given up hope that EBC would publish it, he called me personally to say that they had changed their mind and now wanted to publish it. I learned later from my friend Bhumika, who's here today, who works with Mr. Malik, that he had shared my manuscript with a very eminent lawyer for editorial review, Mr. Murali Neelakantan, and I must acknowledge him, who saw the importance of a practitioner's guide, as opposed to a traditional commentary, and thus gave his recommendation to EBC to publish it. So I remain grateful to Mr. Malik for making the right decision to publish my book and for not sending me down the road to LexisNexis. Now, coming to the second aspect of what drives us criminal lawyers. The most fundamental aspect of our justice system is founded on the legal principle that every person accused of an offense is presumed to be innocent, unless proven guilty beyond all reasonable doubt and by a procedure established by law. my very distinguished senior colleagues from the bar who are present here today represent the entire spectrum of the legal field, from being prosecutors for the premier investigating agencies like the Enforcement Directorate and the Central Bureau of Investigation, and of course, the instrumentalities, the other instrumentalities of the Union of India, to those like myself and Mr. Agarwal, and of course Mr. Nadkarni, who's now on the private side, and Mr. Ghosh, who appear on the defense side representing accused persons. So the entire spectrum is, I think, here today. And even though we find ourselves opposing each other most vigorously on any given day in the courtroom, we are actually bound by the very same dharma that we worship every single day, which is our constitution. Even the honorable judges who hear our arguments and our submissions ultimately decide the merits of our cases, of our clients' cases, I beg your pardon, sir, either directly or indirectly on the sacred principles of the Constitution. This, in my humble opinion, is the true beauty of our legal system and our great country. That even though we fight for our clients' interests, it is always within the four walls of laws that our Parliament enacts. And these laws are in turn subject to the strictest scrutiny by our Supreme Court, so that they never violate the fundamental rights that make up the bedrock of our Constitution, which is what we lawyers adoringly refer to as the basic structure of our Constitution. The same spirit of fairness in protecting individual rights, especially those of a person accused of an offense, unites our legal fraternity. No matter how heinous an allegation might be, I can proudly say that not one lawyer in this room would deny that person their right to a fair trial. But what does this word fairness really mean? How does one define this quality? And how do our courts ensure that every accused person, even those charged with terrible offenses, are entitled to it? The answer to that, in my respectful submission, is a commitment to procedural fairness, which was the topic of our panel discussion today. I want to end my remarks today by echoing something that Justice Maheshwari, in fact, held in a recent judgment in Vasudev versus State of MP, in which he has underscored the cornerstone of our criminal legal system, which is to say that the necessity for the prosecution to prove its case beyond all reasonable doubt. This principle reaffirms our commitment to procedural fairness and justice. In closing, I extend my heartfelt gratitude to everyone present here today who made it here. Thank you very much. Thank you.
Imagine I have to speak after Mr. Dehadrai, the height difference. Thank you, Mr. Dehadrai, and congratulations once again. I would now like to invite Mr. Malik to speak a few words.
Justice Maheshwari, Mr. Mehta, our esteemed panelists, may I seek an indulgence for just, it's getting late, but just a very short thing I want to mention. So as, as our role as publishers, we also see ourselves as the custodians of the legacy of authors. And just as Jai joins us today as an EBC author, one of them has left this pantheon. I would like to request everyone's indulgence to stand and observe a minute's silence in honoring the memory of Professor K.N.C. Pillai, former director of ILI and the Bhopal Judicial Academy. Professor Pillai was an academic and a teacher at heart, the editor of the journal section for SEC, and foremost a gentleman and a great friend of the EBC family. He and his words of encouragement will be greatly missed. We extend our deepest condolences to his family and to his admirers. Thank you.
Time has flown by, and as we approach the conclusion of this extraordinary event, I would now like to invite my colleague, Ms. Nilufa Bhateja, Senior Associate Editor, EBC, to deliver the vote of thanks.
Good evening, everyone. It is not every day that such an august gathering comes together under one roof. Today is one such occasion where the stalwarts of the legal profession have come together to commemorate the release of Jai Anant Dehadrai's Prevention of Money Laundering Act, published by Eastern Book Company. As we come to the end of this wonderful evening, I must thank all those who have gathered here to celebrate this momentous occasion. As one of the great Roman scholars, Cicero said, "Gratitude is not only the greatest of virtues, but the parent of all others." First of all, I would like to thank Justice Maheshwari and Mr. Tushar Mehta for taking out time from their precious schedules and to be part of this event. To Mr. Nadkarni, Mr. Vijay Agarwal, and Mr. Sanjoy Ghosh for taking part in this wonderful occasion. To Ms. Agam Kaur, who has very kindly agreed to be the moderator for this event and has conducted this session so flawlessly. From an idea in the author's head to a book in our hands, a manuscript undertakes a long journey of manuscript development, editing, proofreading, and much more. We would like to thank everyone who was involved in this journey and those who have come here to celebrate it. To the author and the man of the moment, Mr. Jai Anant, whose years of hard work have finally come to fruition today. To the publisher, Mr. Sumit Malik, for his constant support and mentorship. To the EBC team, and namely, Ms. Bhumika Indolia, Senior Associate Editor, Ms. Praj, also Senior Associate Editor, Ms. Diksha Dabas, and Ms. Sonali, who have worked tirelessly behind the scenes to bring this event to life. And last but not the least, to the wonderful audience. I would like to say a shairi, and I would excuse any mispronunciation. चमन में इख्तिलात ए रंगबू से बात बनती है. हम ही हम हैं तो क्या हम हैं, तुम ही तुम हो तो क्या तुम हो. Without the active participation of the panelists and the audience, the event would not have been what it has. Thank you, everyone.
Leave and please join us for the cocktail and dinner.